DLO to deposit a deed in the direct name, but the DLO has not complied. And Your Lordship, the state had filed a counter affidavit, but a copy has not been served to me. In spite of repeated requests, they have not served this counter.
We are in the midst of a partnered matter. We can't just take up the matter like that. Okay.
Supplementary is item 3, first appeal 367 of 2018.
With my lord's permission, yesterday,
The written submissions. Yes.
yesterday, my lord, I was reading section 7 and I'd like to make submission that if there is no agreement reached between the parties, there is no choice of the Union of India to not to appoint him. In this light, my lord, will you allow me to read the order passed by the Honorable Supreme Court? Before that, my lord, the irrevocable judgment or the impugned order before the Honorable Supreme Court of India passed by the division wing of this Honorable.
Which judgment are you placing?
Yes, my lord, it is the Supreme Court judgment, my lord, that is exhibit 11,
Exhibit?
that was executed before. It is in the appeal also, 2034-40, the next, by which the
You see,
arbitrator.
we are only picking up 2 files, right? So whatever has been exhibited before the court, you just mentioned. Don't refer to other appeals, otherwise we will get.
Very well, very good, very good.
Which judgment? Which is the exhibit that you
Yes,
have?
yes.
Exhibit number?
Exhibit number, my lord. Order number.
Exhibit number?
203, it is there.
You must be knowing the exhibit number.
This was not showing in exhibit, but by that order, arbitrator was appointed.
Okay. In which record this order is there?
It is FA number 203 of 2014.
Where is it annexed?
Just after the memorandum of appeal, order is annexed. Before the award. Number 203 or
इनको बताइए कौन सा डॉक्यूमेंट?
I have given you the hard copy of the same.
उसमें तो नहीं मिला. Anyway, this is what you are referring to.
Yes. By this order, this arbitrator was appointed, by Honorable Supreme Court of India. This order was challenged, passed by the division bench of this honorable, declining my request for appointment of the arbiter.
Where is the order of the court?
The High Court below.
Yes.
That is not here, but it is reported below.
CWDC 2273.
Yes.
Where is that order? Show us.
In the meantime, allow me to read below this order.
What was the name of the party? 2273 is Virendra Mehta.
Virendra Mathur. A detailed order was passed. Whatever they are arguing now, all these things were argued before the High Court, and that was not accepted by the Honorable.
First we place the writ order.
Yes. I should read from start.
No, you just tell us what was the matter.
Tell me, Lord.
Petition number 1 to 20.
Paragraph 3.
You just read para 1 and then.
Yes. The petitioner number 120 who belong to court building on behalf of 753 land owner of said village had filed this petition praying for reversing of the notification issued on 18/11/1993 by the state government cancelling the earlier notification dated 5/6/1993 issued on the basis of the letter of the Deputy Commissioner Ranchi dated 30th/10/1993 and restore the notification dated 5/6/1993 issued for appointment of the arbiter in respect of all the land user under section 8(1)(b) of the Constitution for the year. Here, my Lord, the DT Commissioner, after having found that all earlier, my Lord, the notification was issued for certain persons, but Deputy Commissioner was found that other land
That
user-
notification was also issued pursuant to an order of the High Court.
Yes, ma'am.
Which is that notification?
That is not here, my Lord.
You don't know the number also.
I will find out. So, I am just saying, my Lord, the Deputy Commissioner himself, the competent authority himself, included the name of all the person. He found that it should not be restricted to certain person; it should be to all person in the that mentioned in that notification. It is, Lord, in the facts it will come, Lord. The state of Bihar, now Jharkhand, on requisition of Defense Department of India, acquired a vast tract of land in four villages, namely Sugnu, Gadi, Lalganj, Kaduna.
This has already been placed.
This judgment, I am just saying, I am not listening, I am saying this was the division bench judgment, where all the argument now they are taking have been argued, the petition was dismissed, but this order, against this order, special leave was granted by the Honorable Supreme Court, so this order does not add on today, does not exist, it's merged with that order.
They are not relying upon this.
No, whatever argument now they are arguing, all these arguments are here. Even Munsa judgment, by relying on Munsa judgment, the High Court has discarded my plea. Supreme Court said, so now man, allow me to read that Honorable Supreme Court of India, because their argument on three limbs. First, most of the ground in appeal and before the arbitrators, they said it is restricted to only 20%, not for all person. Second, they are saying, Lord, they whatever amount they have given, that is sufficient. No additional amount should be granted to the petitioner. And third, they are saying, Lord, solicium and interest should not be granted to them. Only three limbs of argument are there. I am on first limb of argument. They are wrong in saying that arbitrators should decide only against the 20%, not all the person they name in notification. Kindly allow me in this slide, Lord, to read this very small order, Lord, to this honorable Supreme Court. By reading this order, I will tell you, Lord, if they did not go for review of this order. So now, reopening those things is amounts to interference of the order passed by the Honorable Supreme Court. Kindly allow me, my Lord, leave granted, being agreed by the judgment and order passed by the High Court of Jharkhand at Ranchi CWJC 2273 of 1994, dated 10/1/2008, the appellants are before us in this appeal by special leave. By the impugned judgment and order, the High Court has rejected their petition wherein they had sought for a simple and equitable relief of appointment of an arbitrator as provided under Section 8(1) of the Acquisition and Acquisition of Movable Property Act 1952, the Act foresaw. The factual matrix of the case reveals that lands of the appellants and similarly situated persons have been requisitioned by the central government under the aforesaid Act. Thereafter, since an arbitrator was not appointed as required under the Act for deciding the compensation payable to the land users who have lost their land pursuant to the requisition made by the central government, some of the land users had filed a petition before the High Court inter alia requesting High Court to direct the respondent to appoint an arbitrator to decide the claim for a reasonable compensation for having lost their land. The High Court, considering the plea of the petitioner therein, had in fact directed the respondent to appoint an arbitrator, a retired High Court judge, to consider the claim of the petitioner in the said petition. Similarly situated person had approached the state government to issue an appropriate notification relating their matters also before the arbitrator. The state government, by issuing a notification dated 5/6/1993, has referred the case of all the persons notified under the notification for adjudication. With my Lord permission, I call here, Lord, the state government itself, to all the persons claimed by for compulsion by an arbitrator. Subsequently, the said notification came to be withdrawn for the reason based on them alone. Aggrieved by the action of the state government, the petitioners went before the High Court in writ petition number 2273 of 1994. The High Court, in our opinion, kindly mark these two words, very strangely has dismissed the writ petition filed by the petitioner. That is how the appellants inter alia claiming that they have filed this appeal in the representative paper. Lord, kindly, again this matter representative capacity, the SLP was filed. That was accepted by the Honorable Supreme Court. We have heard Mr. Raghu Patil, learned senior counsel for the appellant, and Mr. Paras Pura, learned additional solicitor general appearing for the respondent. In our opinion, it may not be necessary to go into the detail of the case, since we are of the considered opinion that High Court was not justified in rejecting a reasonable request made by the petitioners. So our request was found reasonable, and the action of the High Court was found not justified. In writ petition number 2273 of 1995. At this stage, we also take note of the fact that persons who have lost their land because of the requisition are over illiterate scheduled tribe people. In a matter of this nature, in our opinion, the true concerns would have prevailed on the respondent who have accepted the reasonable request made by the appellant instead of arguing the matter on technicality. So, Lord, the assertion has also been charged, Lord, upon the respondent why you are not accepting this plea. Para 7.
I have read it.
I view of the above while allowing this appeal to be restored and order notification pass issued by the state government dated 5/6/1993. We are informed that arbitrator appointed under the aforesaid notification is no more. Therefore, we direct the state government to appoint a new arbitrator, retired High Court judge, to decide the lease between the parties. Can you mark lease? What is the lease? I will explain later. lease between the appellants and others also in respect of those persons who have lost their land pursuant to the notification issued by the state government dated 5/6/1993 as expeditiously as possible at any rate within a month of time from the date of receipt of this court's order. We further request the learned arbitrator who may be nominated appointed by the state government to decide the lease between the parties as quickly as possible in view of the fact that the acquisition of these lands was done by the federal government way back in 1972. We have not expressed any opinion on the merit or demerit of the case of the parties of the lease. So, my lord, they are taking this line. As per my understanding, Lord, lease between the parties that how much we are affected by not getting a appropriate proper compensation. They are saying we have paid the proper compensation. So whether the proper compensation has not been paid or not, that is the lease.
See, before the arbitrator, everything remains open. It was just an arbitrator who was appointed. You cannot say that the arbitrator cannot go into the issue as to whether the claim should be enhanced, not enhanced, what is the status of the parties, whether they have accepted the award or not, whether they have filed any claim or not. These things, we cannot restrict the jurisdiction of the arbitrator.
Kindly appreciate.
I have understood your argument. I am expressing what I feel about it.
Absolutely, I am telling you, Lord, in this act, Arbitration and Conciliation Act is not applicable.
Yes.
So section 9 will not, where the Arbitration Act you can take plea, this technical plea, whether you are entitled or not. Here, my lord, I will reading, my lord, I will read. Arbitrator has to decide the claim made by both the parties. That's the restriction of the arbitrator. Before that, my lord, coming to the act, yesterday, my lord, one judgment placed by my learned senior, the constitution being judgment. Kindly mark the only one line, paragraph mark. Kindly take note, paragraph 6, line 4. This is judgment, my lord. Union of India, Kamalabai, Harjivan Das Parekh and others. Paragraph 6, line 4. Section 8 of the Act has a marginal note, principle and method of determining compensation under clause A of subsection 1 of the section 8 compensation to be paid in accordance with the agreement if any reached between the owner of the government. If no such agreement can be reached, an arbitrator, and mark this line, has to be appointed for the purpose of the terms clause B. So this is the constitutional judgment. They are placing that two judgments. That judgment cannot be read in light in view of this line of this honorable constitutional bench. Those two judgments, my lord, that is per incuriam in the light of this constitutional bench judgment. So I summarize, my lord, that if whether we have paid money or taken money, if we are not satisfied with the money, once the arbitrator has been appointed by the Supreme Court, it's deemed that we have not satisfied with the money, there was no agreement, and now the arbitrator, before appointment of arbitrator, nothing can be argued. They have taken the money, they have not taken the money. Once the arbitrator has been appointed, it's deemed to be taken that we have not taken the money with our free will. We are not in agreement of the money given by the government. Then, my lord, kindly have, my lord, allow me to read section 8. Once the arbitrator is appointed, how to proceed? I am placing, my lord, 8 subsection D and E. At the commencement of the proceeding before the arbitrator, the central government and person to be compensated shall state what is their respective opinion in their amount of compensation. So the list which I have, my submission, ultimately my lord, relative to Lord, it is list what should be the compensation given to the land users. Then Lord E, the arbitrator shall after hearing the dispute make an award determining the amount of compensation which appears to him to be just. So it is, my lord, the power given to the arbitrator just and specifying the person and person to whom such compensation shall be paid, and in making the award he shall have regard to the circumstances of each case and provision of subsection 2 and 3 so far as they are applicable. So far as they are applicable. It is not again, my lord, it is mandatory for the arbitrator. So far as they are applicable, in my view in reading of this section, the arbitrator is given an authority to apply his mind as per the circumstances of the case. There is no method the arbitrator should go like this, Lord. That is my humble submission. And kindly note, Lord, against this Supreme Court order, they have not filed any review petition. They have accepted the Supreme Court petition. Lord, we have filed before the arbitrator our written state argument.
What is the meaning of a just compensation?
Just I was looking, Lord, yesterday in the meaning, the dictionary, what is the meaning of just means not fair, reasonable, according to the prevailing circumstances.
Just means reasonable.
Reasonable, fair. So the first meaning is fair.
Fair and reasonable, right? So far as the computation of compensation is concerned,
Yes.
Is there any specific method provided under the Land Acquisition Act?
Land Acquisition Act, my lord, the section 23 market value, which was, my lord, that is the series of judgments that governs the field.
So here also, when we talk about just, fair and reasonable compensation,
Yes.
is it relatable to market value?
Yes, of the market value he has to ascertain.
That's right.
At the time
so
of
the
acquisition.
parameters of computation
Yes.
in case of Land Acquisition Act
Yes.
and in case of this act
Yes.
is one and the same.
Yes.
Parameters of computation are the same.
Yes.
Correct?
Yes.
So
Parameter I will come, my lord, the latest judgment of the Honorable Supreme Court, the Okla Development Authority. In this, similar the legal judgment passed by the Honorable Supreme Court and the various High Court, that governs, there are various, the future perspective, area of
there
location.
are the parameters. So same parameters can be applied.
But court says that even though that is not final, even though court is saying that is not final, it depends upon each and every case, the circumstance.
That's right, but some guideline has been laid down judicially.
That.
Otherwise, in the act, there is no guideline.
Otherwise, arbitrator has to take note of that.
That's right.
Then, Lord, we have filed a written argument before.
So let us see the criteria.
Yes.
Let's complete this part.
Yes.
What is the method of computation? Which judgment are you relying upon?
We have filed a number of judgments.
No, you see, the
I
judgments.
read only one judgment.
The judgments which you will not place it before the court, I will say that it has not been placed.
No, why would we have placed, my lord?
Whatever judgments you will place, only those judgments will be taken care of. Merely because you file judgment, that is of no consequence.
Okay.
That is of no consequence.
Yes.
You have to place the judgment. Which judgment do you want to place?
Okay. I thought not I will place the judgment at the same.
No,
time
you
of
just,
session.
because it is the parameters, which parameters are to be taken into consideration.
This is the copy of the 2024 SC online FC 1699.
The judgment is not there in the bunch. You have a copy of the judgment?
Yes.
2024 SCC online. Page number?
Page number, my lord. 1691.
1691. Para number?
Para number, my lord, 35.
35. This is Okla judgment.
Yes, Lord.
Yes, please skip to.
Yes, ma'am.
Mode of computation, right? Which paragraph are you referring to?
35.
Kindly read.
Characteristic of the land. The valuation of land is undeniably influenced by the inherent characteristics of the parcel of land endowed with advantageous features that enhance its accessibility, utility, tends to
Because
command higher.
my काम नहीं कर रहा.
I'm sorry. The valuation of land is undeniably influenced by its inherent characteristics. The parcel of land endowed with advantageous features that enhance its accessibility, utility, tends to command higher market price. Thus, the greater valuation in computation of land lacking such attributes. Key factors contributing to such features include connectivity via roads, other means of transportation, the size and shape of the land, ability of essential utilities such as electricity and water, wilderness and labeling of land, surface, means of frontage, nature of the status of the surroundings, area, etc. In addition to the characteristics, the valuation of land are also influenced by potentiality. Lands with the potential to be used for commercial or residential purposes that are located in near a developed area, which are approximate to tourist destination, are perceived to hold greater value in the future. Consequently, landowners may anticipate higher future price and accordingly demand higher sale prices compared to the land lacking these attributes. Accordingly, these features are lead to an increase in valuation. Factors denoting market sentiment are to diverse for land valuation. Even if a particular piece of land possesses all desirable features, its valuation can still suffer in the market condition at the time of publication of the business and unfavorable factors such as economic recession, political instability, speculative investment, and real estate crisis can market impact the perceived value of the land. These exceptional economic and political factors may also be considered when assessing land valuation. Then not other
These are the factors to be. These are the
Here are-
factors to be taken into
Yes.
consideration. I want to know the method of computation. Like examples of salients are to be taken into consideration. And there are many other things also. Circle rate, if at all, is to be taken
in
into
that
consideration.
one latest judgment, my lord.
Which is that these are the basically
I
the
mean the factors to be
factors
taken.
to be taken into
This is
consideration,
the
right?
situation of the land.
It is not the mode of computation, factors to be taken
Features,
into consideration. And the whole idea is to find out whether the method which has been adopted by the learned arbitrator has been recognized by law in any judgment, or he has adopted his own method. Because I just want to know, is there any such kind of method that for 10 years, 15 years, you will count it down by 10% each and then increase it by 10% each? Is it a permissible method of calculation
Not,
under law? So just cite that judgment,
yes,
which gives the method of calculation.
yes, yes.
These are the parameters, well-known parameters.
Yes. Lord, I was doing kindly take note of that. We filed our written argument before the arbitrator. And in
Before we enter into the merits of the case, I just want to know from you, what are the methods of calculation in case of NAC? General principles. First you place the principles, then we'll see the facts of the case. Because the principles which a learned arbitrator has appointed, I have not come across this principle yet. So I just want to know whether this kind of principle is otherwise permissible under law, because the Act is not giving any guideline. Act is not giving any guideline.
one recent judgment, my Lord.
So which is that judgment? Please place it. You just finish your argument on the principles of law so far as the method of computation is concerned.
I go on because I thought, my Lord,
I know
Generally-
you must have prepared it in a
generally, my Lord,
particular
in
way.
our where we first place the.
We have seen the facts for
No,
last
no,
2 days.
No, my Lord, that those some certain facts have been.
We will see that. We will see that. But
In,
I
in,
just
but
want.
I clearly submit, my Lord, I yesterday since I was not well, I was trying to find out something. One judgment, my Lord, we find a recent judgment where 6-7 year de-escalation method has been adopted by.
Which is that judgment? And under what circumstances this kind of method is adopted? Under what circumstances this kind of method is adopted? I think, I assume so, that such kind of method would be adopted in a circumstances where there is no comparable sale available
Yes.
for comparison.
Yes.
When nothing is available, then some remote sale deed can be taken into consideration by computing the de-escalation or escalation of the prices as the period may be. But once there are materials of that particular time, then can a average be taken? Or it is like, one after another. If first method, if exemplar sale is available for that period, nothing else is required to be looked into. Why should anybody go to see anything else apart from the fact that proximity and these factors, what all factors you have said? Apart from that, nothing else is required to be considered. But the learned arbitrator has adopted a hybrid mode. He has taken de-escalation, he has taken escalation with respect to one sale deed, de-escalation with respect to another sale deed, and he has come up with multiple acceptable documents, and then the calculations made, and then he takes an average. Is this kind of method?
May not be, my Lord, I clearly submit, my Lord, may not be. But,
Such
my Lord,
hybrid approach.
with caveat, my Lord, with great respect, that one sale deed which yesterday which was delivering the 1971.
You please refer to that judgment which you have, recent judgment you are saying, where is that judgment?
My Lord, I am Ramkishan.
Anyways, if that judgment is not there with you, we can't do it.
Replace me.
Yes, continue.
Yes, but I was looking at a lot of asking judgment. Yes. One judgment may not be filed, but what is the definition? Judgment definition. This is not 2008-17 SCC 133. Sardar Yoginder Singh versus State of Uttar Pradesh.
Which para?
Lord, it is paragraph 18, my lord.
Para 18, this is concurrent finding of the
But
tribunal
the
and the High
tribunal
Court.
was affirmed.
No. There 18 says there is a concurrent finding of
there's a
tribunal and the High Court.
Yes, my lord.
We are still in the High Court.
Can you allow me to read para 13, my lord, from 13. Each case related to an accusation in the year 1979, they relied upon award related to an accusation of the year 1969. The general increase between 1969 and 79 can be taken to be around 8 to 10% per annum
If the sale increase is calculated cumulatively, we find the total increase for 10 years would be around 100%. Therefore, the assessment by the tribunal affirmed by the High Court does not suffer from any impropriety. The other evidence also broadly supports such an increase. There is nothing to show that market value would be less than 3 per square feet in 100%. Therefore, we find need to reduce the market price fee at the.
You read para 12 also.
Yes, sir. On ONGC Limited, Ramesh Bhai Jimenbhai Patel, this court held that in regard to the urban city urban area, in the absence of other acceptable evidence, the cumulative increase of 10%.
In absence of other acceptable.
Yes.
It is not that everything can be taken in a hybrid way.
No,
In absence of acceptable evidence. Once there is an acceptable evidence with regard to the date, area, place of acquisition, by way of example, then under such circumstances, where was the occasion for the learned tribunal, arbitral tribunal, to adopt this 10%, 15% increase? This is what I am asking. भाई फर्स्ट नहीं आए तो सेकंड से चलेगा, लेकिन अगर फर्स्ट है तो सेकंड से कैसे चलेगा? समझ आएगा? बस. This is the maximum I can explain what is going on in my mind.
In that also is going in my mind also, because whether the arbiter which has adopted this practice, whether it is permissible in law or not. I am just on that I have in my mind. My challenge to this appeal will not weigh that I have placed the earlier awards, earlier judgments, those were how to have considered before fixing the market value. Even though the arbitrator is wrong, taking this kind of method.
First, let us be clear from your part that the method adopted by the arbitrator is incorrect. Do you want to say that?
No, Lord, for that I need at least half an hour time so that whatever I will submit, Lord, that should be correct. I should not make any incorrect statement.
Yes.
But I am saying, Lord, that's why, Lord, I am saying, Lord, why my challenge to what extent I have challenged this arbitrator award, way that proper market value has not been assessed, ignoring two of my valuable documents.
Two valuable documents have been ignored.
Ignored.
Which are exhibit?
Exhibit, my lord, which are exhibit 12.
Exhibit 12 and?
Lord, exhibit 12, I am more harping on this, and exhibit 4.
These two documents have been discarded.
Discarded on wrong assumption. A perverse finding, I can say, with great respect. And these two, because the earlier judgments, nearby village or award, and moreover, which has a validity sanctioned by the higher court, is, my lord, one of the best criteria to fix the market value.
These are the two judgments.
Yes.
Yesterday also we had noted it down.
Noted down, but those facts, my lord, somehow escaped, which I want to.
Okay, just a moment. Exhibit 12.
12.
It relates to acquisition of?
No, it's a judgment of Honorable Supreme Court of India.
Relates to acquisition of?
To the acquisition of ward number 3 of 1954.
Ward number 3 of 1954.
Ward number 3 of Ranchi municipal area.
Okay, but of the year date of acquisition is 1954.
I am giving the exact date.
We have noted it down yesterday.
There is no research.
This we have noted.
Yes, sir.
So this is exhibit 12.
Yes, but why the arbitrator has not been considered this document. Arbitrator can discard my document, giving us region, but not on that region. Which region the arbitrator has discarded is absolutely
The
wrong.
first appeal can also reject a document giving a different reason. With 1954 document, acquisition date,
Yes, ma'am.
no, nothing can be done.
Let me allow to place that.
Yes, I am allowing you. I am allowing you. It's not that. I have not closed my mind. But I am just.
Ultimately, my lord, to have to decide, my lord.
What about exhibit 4?
Exhibit 4, my lord.
Date of acquisition?
Date of acquisition. Exhibit 4, the 28/8/1971. This relates to ward number 5 and 6.
It's in Doranda.
My lord, the
This is
evidence,
in Doranda.
evidence has come. Gari falls under ward number 4. That evidence I am.
What falls under?
Ward number 4. The land is in question.
Is in ward number 4.
Ward number 4. That has come, my lord, in the evidence of their evidence, my lord. It's a DW3. DW3, my lord, para 8. Page number 2, my lord. This is deposition of Abhay Narayan Ambassador. This is, my lord,
Is the claimant?
district land acquisition officer. The 28th September 13th, deposition was recorded on behalf.
Abhay Nandan Ambassador.
Yes, ma'am. Abhay Nandan Ambassador. Paragraph 8, over the page number 2. That village Gari is within ward number 4 of municipal corporation. I'll place not this to here why the arbitrator has not considered this document and why the reason given by him is sufficient or not. 4 and 5, my lord, one acquisition sanctioned by the, my lord, the appeared by the honorable court, and ward number 3 is also by the honorable court.
All the villages are in ward number 4. He only says village Gari is important.
They are saying contiguous, but
But
evidence.
ward number can change. Even if it is contiguous,
It
are
is-
they all falling
It
in
is
what
not on
number?
record, but there. Lord, kindly have me Lord the award first.
Internal page 25.
Lord, the internal page 25.
Bottom, exhibit 4.
Yes, the claiming documents which are not relied by this tribunal are first, Exhibit 4. The said exhibit is judgment of the Honorable High Court in April number 220 of 1997 R 6290 in relation to the land situated near railway station, bus station which were acquired under the LA Act on 28/1971 and for which compensation and 2,50,000 per area were awarded. However, in view of the proximity of the said land near a railway station, bus station, I am not inclined to consider this said. I would kindly have exhibit 4 first.
Who has exhibited this document? Which witness?
Yeah, this was filed by us.
It was simply filed.
Simply certified copy. The certified copy filed. Exhibit 4. This is the judgment of my Lord Justice. The IEC, the appeal is directed against the judgment dated passed by MP Verma. And it would allow the application in part 5 and
It is within Ranchi municipality.
yes.
Are these lands also within Ranchi municipality?
That is ward number 4, Ranchi municipality.
One of them. So it is ward number 4.
Oh, yes. Admittedly, notification under Section 4 of Land Acquisition Act was issued in 28/8/1971, wherever under the Land Acquisition Act, decision of land constituted ward number 5 and 6. Doranda within Ranchi municipality is sought to be acquired a declaration under Section 6 of State Act was issued in 1971. The land in question in two blocks, that is block number 24, being housed by building area of 9-8 career and block B, block number 24, building area 222 career, thus measuring a total of 300 career, which is equivalent to 30 decimal of the land. The learned land acquisition here, they granted compensation of 66,550 per acre in respect of plot number so and so, and compensation of rupees 39,930 per acre in respect of plot number 2631 of it. According to the appellant, the land in question is situated in the heart of the town and the commercial area. It is further alleged that there are safe on both sides of the roads and land in question is very near to railway station. Kindly mark this question below. The word very near to railway station. They have not given the distance. Depot belonging to the Bihar State Road Transport Corporation. According to the appellant, the land in question have potential value of the same side of the main road. In fact, the land in question was acquired for construction of the overbridge. The appellant claimed compensation for a sum of rupees 1 lakh only, ordered the London Court below granted upon consideration of the evidence on record a sum of 223,500 apart from the statutory solution of interest. This appeal is value
at rupees 66,500. Mr. N.K. Prasad, the learned counsel for appearing on behalf of the appellant, submitted that in view of the fact that deed of sale date 2012-1982 was moved on behalf of the appellant, wherein it would appear that 11 kathas, 12.5 lease of lands were sold for a sum of 55 lakh. The land unit would below out which have paid the compulsion shall be awarded for the division of the land in because of that per katha. The learned counsel further admitted that it is true that by reason of the new highway, which is the sale date of year 1971, the land which was the subject matter of the sale date was sold to 1500 per katha, but there are evidence to show that the said land was situated at a place far away from the main road. The learned counsel therefore submitted that valuation of the land situated in the commercial area being near to the railway station and bus depot of the Yard State Road Transport Corporation, that too by the side of the main road cannot be equated with the value of the land which is situated
Of
far away from the
1977.
main road.
220.
220 of 1977. One page is missing. Page number 4 is missing. Exhibit 4 का page 4 यहाँ से missing. 6 January 1990. 6 January.
It is 1990 SCC online Patna 417. 1990 SCC online Patna 417.
इसमें डाले हैं क्या? नहीं, ये तो आपका कॉपी है ना?
जी।
आप we will get it.
Soft copy may be needed.
You have given it for us also.
I have get it ready for my lord also. So, just I'm sorry, because actually yesterday my health was not able to see. That's why a little bit I'm not able to assist. Maybe back pain or extra.
That's right. Para number 19.
Yes, sir.
You did para 18 and 19.
Right. In Srimati Triveni Devi, collector of 1972 PM year 509, the Supreme Court laid down the criteria upon which the court should pass its decision including the value of the land in the following terms. Compensation payable to the owner of the land at the market value which is determined by the reference to the price which the seller might reasonably expect to obtain from a willing purchaser. But as this may not be possible to ascertain with any amount of precision, the authority charged with the duty to award compensation is bound to make an estimate judged by an objective standard. The land acquired has therefore been valued not only with reference to its condition at the time of declaration under section 4 of the Act, but its potential value also must be taken into account. As indicated earlier, the methods of valuation to be adopted in ascertaining the market value of the land on the date of the notification under section 4(1) are opinion of experts, the price paid with reasonable time in bona fide transaction of purchase of the lands acquired and possessing similar advantage. A number of years, however, do not preclude the court from taking any other special circumstances into consideration, the requirement being always to arrive as near as possible an estimate of the market value. So, my lord, any special circumstances can be taken care of.
Para 19.
Taking thus all aspects of matter into consideration, in my opinion, as no deed of sale has been proved with regard to the 10 lands near about the land in question, it will be just improper to award in that circumstance of the case regarding add to the fact with the land in question is by the side of the main road, the other near the railway station, bus station, other important office, and having great commercial value of rupees 2,500 per decimal, which will meet the end of justice. So why I am submitting, my lord, this judgment, my lord, discarded by the arbitrator by saying, in this case, the land in question is near the railway station, and my land is not near the railway station. Though it is not written, I am just extending the word. Now, my lord, kindly see the evidence where my land is situated.
There are 4 factors which have been taken into consideration.
Yes,
One is it is by the side of the main road. Second is it is near the railway station.
yes. No, what the
Bus
arbitrator has said.
stand and other important offices, and was also having great commercial value.
I am saying what the arbitrator has stated for not taking my.
You see, we are scrutinizing everything.
Yes, ma'am.
It is a first appeal. No, don't revert back to the arbitrator.
No, I am saying arbitrator is wrong.
Maybe he is wrong, but still we may have separate reason for not relying upon this document.
Yeah, my lord, obviously.
So therefore, we
No,
are
but
just,
I am showing.
there are,
I am showing
yes,
what.
arbitrator has rejected it on a very, very different ground completely, right? That we have seen, it's a very short order, short discussion so far as this particular document is concerned.
So, my lord, I am just requesting, kindly see what evidence of mine has come. Whether it was away from the railway station.
No, yesterday he has placed it, please don't.
No, I got this.
He has placed on the point of valuation, he said that he has completed his argument. You were supposed to argue on other aspects of the matter.
Other aspect with
Now
that.
please do not divulge
No,
on the
I
same
will
points. He
not
has
say-
already placed.
One point, my learned senior may not have seen, Lord, that the evidence has come that the Nampum station is 3 to 4 kilometers from my land.
Nagpur railway station.
Nampum railway station. 3 to 4 kilometers from my land.
Who has this witness has said this?
Yes. That's only all. I am not for reading the entire things. It is not every, because all the say TW1 my lord can take. And the Tati Silve railway station is nearby. This evidence has come.
3 to 4 kilometers, Nagpur railway station.
And your evidence has come, my lord, that Doranda is 4 kilometers from our landing post.
Just tell us which one, PW1, which station?
TW1. All the and all the it has come. ये कि गाँव के 2-3 किलोमीटर पर रांची क्लब के निर्माण हेतु 1954 में कंपनी स्टॉकिंग वर्क की जरूरत थी। 1971 में रांची शहर के दक्षिण गोरंडा में गांव से जोड़ने के लिए सरकार द्वारा जमीन दी गई। इसी एग्जीक्यूटिव और एग्जीक्यूटिव 4 कटियाटू जमीन लगी, जिस आर्बिटर 2 लाख का नाम अगस्त 2005 में कटियाटू गाँव शहर से 12 किलोमीटर दूर है। हमारे गांव के दक्षिण और 3-4 किलोमीटर के नामकुम रेलवे स्टेशन को छाड़कर दूसरा रांची शहर 10 सालों से बड़ा सही समाज कैपिटल एंड लास्ट पेज में चारों गांव एक दूसरे से पेज नंबर 2 में एंड पैराग्राफ 2 सभी 4 गांव एक दूसरे से सटा हुआ है। दक्षिण पूर्व में नदी पास काफी से गांव है, तरह के उद्योग धंधे हैं, कारखाना है, उषा मार्टिन मिट्टी का कारखाना, स्कूल, प्राथमिक विद्यालय, हॉस्पिटल, चावल मिल, आटा मिल, ट्रांसफर कारखाना, गोदाम, दुकान फैक्ट्री है। उसके बगल टाटी सिवरे रेलवे स्टेशन। 2 stations are nearby my land. Lord, it is not that, Lord. Kindly, my Lord, note my this argument, my Lord. These statement depositions were not, my Lord, controverted by the Lord the respondents. No, Namkum is not near 3-4 kilometer or land has not been taken for that. Kindly, for my satisfaction, my Lord, kindly have the cross-examination. What they have done, what they have put to this. Witness, and the 4 witnesses have stated on the same line, and the nothing cross examination, Lord. Kindly see there, allowed to read not from 7 number page. Was you also one of the petitioner in Supreme Court? Who were the other petitioners regarding which village power had been given to the arbitrator? Can you say the extent land of each village acquired in proceedings? What was the number of award? What was the extent of land involved in your award? Question 7. Whether you are concerned only with village Sugnu. 8. What was the extent of your land acquired in village Argan? What was your award number in village Argan? Can you tell Katha plots number both village? Where your land belong to Katha number 7? Question 12. Do you remember the plot of Katha numbers? 13. Can you tell the types of grades in land acquired in connection with instant proceedings? 14. Can you tell the details of types of garden land Katha wise? 15. Can you tell the rates paid by the government against different types of grades of land? Then, Lord, whether you potentially have claimed before the tribunal in which your land had been acquired, whether you have deposited the relevant sale date of year 1971, what crops you were cultivating the time of acquisition year 1971, were there any activities going on other than cultivation over the land in question? So I have given, Lord, toward the east, Sugnu, Nalgan, factory, Usa Martin, government, petrol pump, market, where all these things are situated in time of 1970s, except BSNL, Khelgaon campus, everything was there prior to 1971. Whether only NH33 was there in 1971, no, NH32 was also there. So N2 and N12. Are you claiming compensation on the basis of your crop production? No. Have you got your crop value? Whether the abilities of both are similar in common processes. So nothing has
As
been.
per this witness also,
Yes.
the location of the property is at the outskirts of the urban area. Internal page 3. The top one.
यह कि रांची शहर नगर पालिका में है तो
नहीं, यह कि चारों गांव की जमीन रांची शहर से सटा हुआ है, अतः जमीन को शहर की जमीन मानना चाहिए.
रांची
So this area is at the outskirts of the urban area.
I'm sorry, my lord.
चारों गांव 3 तरफ से नदी से घिरा हुआ है तथा पश्चिम में राजमार्ग है. उससे सटे पश्चिम रांची शहर का सीमाना शुरू हो जाता है, जहाँ लाखों की आबादी रहता है, जहाँ शहर की सारी सुविधाएं प्राप्त हैं, जैसे कि बाजार, स्कूल. So the location of the land is just at the outskirts of the urban population of the Ranchi town. This is what he has said.
He said, my lord, with my reading of this deposition, he is saying that Ranchi town, he is taking my lord town as the my lord where everything people are known. उससे सटा हुआ, but does not my humble submission, my lord, does not mean it's undeveloped my land. सटा हुआ है.
Location. We are looking at location.
Yes, location, but it is ward number 4.
Maybe ward number 4. But this is what he has said. You read it.
Yes, my lord.
हिंदी नहीं तो अंग्रेजी में ट्रांसलेट करके पढ़ो.
नहीं, I am reading that.
पढ़िए.
यह कि खटंगा लालगंज के बीच गुजरात में से पेज नंबर 2 मिला. यह कि चारों गांवों की जमीन रांची शहर से सटा हुआ है, अतः जमीनों को शहर की जमीन मानना चाहिए. चारों गांव 3 तरफ से नदियों से घिरा हुआ है, तो गांव के पश्चिम में राष्ट्रीय राजमार्ग 33 है, सटे पश्चिम रांची शहर का सीमाना शुरू हो जाता है, लाखों की आबादी रहता है,
जहाँ लाखों की आबादी।
Yes, maybe
रांची शहर।
maybe in our land there were no lakhs of people on the land. Maybe.
So it is at the periphery of the town.
Yes.
Right? The land is at the periphery of the town and adjoining to the national highway.
Yes. So what I am reading of this.
And this is correct. We are from Ranchi, so we know that this is absolutely correct. Rightly mentioned. There is nothing, you know. You see, Doranda is at the heart of the town. It's at the heart of the town. Our old High Court was situated at the heart of the town in Doranda. So we know, but we are not trying to include any of our personal knowledge into it. What I am saying is that whatever he has said over this, in this portion of the affidavit, is absolutely correct.
Even Milord, I am told me that Gari, this Ranchi clubs comes under the Gari area.
We do not know.
Gymkhana club.
Gymkhana club is much away. If you acquire a land in Doranda and if you acquire a land in Gymkhana, the valuation will be much different. Absolutely different.
That's different. That's like
Gymkhana is much away.
But it cannot.
And this property is much away from Gymkhana also.
But it cannot be from 2,50,000 to 41.
That is another thing. That is another thing.
I'm submitting.
So we are on that exhibit 4, sorry, exhibit 12 or maybe
No,
exhibit
okay,
4, which was a property of Doranda, and it has also been taken into consideration that it was a commercial property. In a commercial area, that property was, there are not only railway station, there are other aspects also which have been taken into consideration.
Yes. I am saying in my case also, there is near 2 railway station, all these factories and everything I have stated. Maybe I am not in the heart of the town, but I'm sata hua hai. But that's why not the 3 kilometer from 3 kilometer they got 2,50,000 rupees. And
See, the valuation of a property which is right on the national highway and the valuation of a property which is 50 meters away from national highway will differ.
But
It will differ.
But not this much, my respectful submission is not this much.
So,
not this much. That's why I'm saying it, the given by the region given by the arbitrator, maybe my lord having a different view. Lord, before going to Lord, exhibit 12, kindly see Lord on record, their record, exhibit 10 exhibit 10, my lord, kindly have for my sake, Lord. Same thing, Lord. I'm just reading, Lord, what training saying, Lord. That exhibit 10(1), that yellow report while assessing the market value, as stated, Lord, agricultural lands of any class near Basti or town are being used for building purposes. So, my land is very much, Lord, for building purposes as per the acceptance of the DL. And I have cited one judgment, my lord, that they can't revert back from their statement. As such, they may be treated as single class of land for purpose of valuation of land, valuation on the basis of their present situation, on the basis of classification of land, on the basis of agriculture will not be applicable. In this case, these lands are near to Ranchi town, what we had also stated, our
which page of the report are you reading?
Exhibit 10, my lord.
Which page?
The internal page number is showing. Just a minute.
After how many pages?
Yes, 1, 2, 3, 4, in 15th. There is written also in the top 1 5. It is on the top. It is written 1 5.
Yes. I
Uh,
got it.
Lord, state the second paragraph. Agricultural lands of any class near basti or town are being used for building purposes.
That's
And such they may be treated as a single class of land for purpose of valuation of land, valuation on the basis of their present position, on the basis of classification of land, on the basis of agriculture, will not be applicable in this case. As these lands are near to Ranchi town and all the lands are from the same status as the land in the occupation of militaries in 1942-43. So far as the purpose of valuation of the entire land has been treated as one class of land, though according to the settlement reports, the lands were recorded in different class. In this circumstance, it is suggested that so and so per acre flat rate takes under condition military and after the publication of notice. So, my lord, it is the DLO is saying, though is accepting what he is saying, Ranchi से सटा हुआ है, but it is very much, Lord, can't be considered as a agricultural purpose. It is the potential value of making building in those lands. So this land is not, Lord, as if this can't be used for building purpose. It only and for कृषि purpose and other purposes. And Lord, if the building will be constructed, Lord, although near the town, the rate should be, Lord, in the higher side. Then, Lord, I'm mostly, Lord, our Exhibit 12. Two things, Lord, I want to go with it. First, Lord, I have to duty to zoom, Lord, why it was not considered by me. Exhibit 12. Lord, page 26. Page 26, the arbitrator has not relied upon this document. And more subject to what my lord is. Our case is based upon on this document.
this Triveni judgment.
This 2 lakhs rupees which we have claimed.
What is the reason of rejection of Exhibit 12 as per the learned arbitrator?
Yes,
Let's
Lord.
have a look at it
Yes,
and then
Lord.
we will
Page
see.
26. That's why I have shown the factors to be taken.
Page 26. उनको बोलिए
Page
नहीं
26.
Yes.
Activity 12, judgment of 25/1/1972 passed by Honorable Supreme Court of India in civil appeal number 6611380 of 67 and 1885/1886 of 967, Srimati Tirumani Devi and others versus Collector of Ranchi. The same pertained to the land situated at between Ranchi Chaivasa Road, and the Honorable Supreme Court fixed the rate of 1,35,000 per acre and also granted 5% severance, 15% suasion and interest 6% from the date of possession. Lord, as per the arbitrator, the land which was acquired in Tiruveni Delhi
was on Ranchi Chaibasa Road. That's why the rate was fixed 1,35,000. In my view of reading Triveni Devi, this fact is incorrect. Because this is the my lord, seek vengeance of the my lord. Because this is the our entire case is based upon this judgment. So kindly bear with me, my lord, for reading this judgment. If 1954, ward number 3 people were getting 1,35,000 in 1971, I will get only 41,000 in ward 4. Maybe, my lord, in 2046 to 71, not 25 years, nearby ward not have been developed, a layman cannot be accepted. May I allow, my lord? Yes. These appeals are by certificate against the judgment of Patna High Court in land acquisition appeals to notification dated July 7, 1954 under section 4 of Land Acquisition Act 1894 Act of 1894 A after Further Act were issued, one in respect of portion of lot number 178 and 178 and the remaining 9.65 acres, and the other in respect of whole of the lot number 1783 measuring 2 acres situated in ward number 3 of Ranchi municipality. Yes, we will mark this note. Section 6 notification in respect of this land was published on September 7, 1954, and possession was taken on September 23, 1954 under section 17(1) after making a declaration under section 17(4) of the provision of section 5A shall not apply. So in our case, it is not in the emergency acquisition. Collector awarded compensation of rupees 1,20,419,611 in respect of first acquisition and 47,648,336 in respect of the second. Thereafter, at the instance of the claimant, a reference under section 18 of the Act was made to the Judicial Commissioner of Chotanagpur, Ranchi, who, while maintaining the market value of the land awarded by the collector, gave further compensation for severance at the rate of 5% and the 10% in respect of potential value of the land. The Judicial Commissioner, however, did not grant 15% solution under section 23 of the Act. Being dissatisfied, the claimants preferred appeal to the High Court. The High Court revised the compensation and awarded 90,000 per acre and 15% as solution on the market value under section 23 of the Act, but did not grant them 5% towards severance. Interest at 6% per annum on the amount of enhanced compensation from September 23, 1954, together with cost was also decreed. Against the judgment and decree, the claimants have filed civil appeal 661 and 1380 of 661, while the state has filed civil appeal 1188586 of 67. The land in question, which have been acquired, were earlier leased on September 22, 2044 to military authorities on a rent of 600 per month for a period of 6 months under a registered lease deed with option to renew for a maximum period of 10 years, which period expired on September 21, 1951. One of the conditions of the lease was the termination of the lease. The leaser would exercise the option given under the lease to purchase all buildings, structure, gardens, and any other structure constructed by the lease during their occupation of the lease property at 75% of the valuation that would be determined by Superintending Engineer Chotanagpur Circle, and in case the lessor refused to purchase, the lease was entitled to dismantle the take away the materials. Towards the end of this deal, the government of Bihar decided to acquire the property of the state soldiers, sailors, and army and court, and initiated proceeding as aforesaid. In this appeal, the only question that has to be determined is what is the market value of the property as on date of section 4 notification. That is not notification date 7 July 1954. In the valuation report given by the land acquisition officer Ranchi Exhibit 1, the principle of capitalization on the basis of 20
and the annual rental of 7,200 at the rate of 600 per month was adopted as the price of the land. In that report, it was also pointed out the sale price of 1085 acres out of the premises of the Ranchi Club as per the registered sale deed Exhibit C1 dated April 1, 1953 was 41,470 per acre, which was not fair. Apart from these, 25 other sale transactions in respect of portion of plot number 789 between 1952-53 were also recorded in that report. Some of those lands were situated opposite to the Ranchi Club and sale price come to 1092 per kattha, which is about 60,000 per acre. It was further pointed out that some other lands in between further away from the main road but belonging to the same plot were sold at the rates of between 250 to 800 per kattha. The reports form the basis of the award made by the collector. The High Court took judicial notice and in our view rightly so that after the termination of the Second War in the 1945 there is a rise in land value due to increased demand of homestead lands for building purposes. It is also considered various safeties produced and proved on behalf of the claimants along with the oral evidence to determine the market value of the land. The objection from both the appellant and the respondents were taken into account in respect of each of the appellant and respondent and these most of them were considered for missing a proper and adequate valuation either having regard to the distance of the lands which were the subject matter of the sale and inadequacy of the information pertaining in respect of the first pertaining thereto. The High Court, however, adopted the price of the sale deed Exhibit C1 executed on May 6, 1953 by Ranchi Club Limited in favor of the President of India in respect of 1085 acres, 3 acres, 5 kattha, 10 chattaks in plot number 1221 for rupees 55 as the basis of arriving at the market value of the land in question was situated on the main Ranchi Chaivasa Road. So, Ranchi Club was in the main Chaivasa Road. Exhibit C1. A strong objection was taken again about.
No, this is in connection with the present case. In this case, this is not in continuation. You see, as the basis for arriving at the market, though the land in question is the present case.
Though the land in question, in my view, I will come to later, my lord, there is some more clarification. Though the land in question is, my lord, the Exhibit C1. I'll come, my lord, later it has been clarified. A strong objection was taken against adopting the price at the basis because it was not only 1.5 mile away from the land under acquisition, but what was sold was only the lease road right in the land. So, my lord, half mile away from the land sold by the Ranchi Club. These objections were rejected on the ground that all practical purposes, the interest which was held, the sold by Ranchi Club.
This was the objection. This objection was rejected.
Yes.
That though the land in question was secluded, this objection was rejected by the court.
Yes.
By the authorities who were assessing the compensation in the present case, not in the case of land.
I will come later. It was clarified. Just allow me. These objections were rejected on the ground that for all practical purposes, the interest that was held and sold by Ranchi Club in this C1 was not inferior to an absolute title. The area of land subject matter sale was considered to be fairly large, being more than 1 acre. The situation was also same in the land under acquisition, except it was further away from it. In these circumstances, the High Court thought and this situation was also seen the land under acquisition, except it was further away from it. In this circumstance, the High Court thought after a proper allowance is made to the difference in distance, the transaction yields a more acceptable guide for determining the market value of the land under acquisition. Accordingly, it adopted twice the price at charge for the land in Exhibit C1 as indicating the higher market value of land in question. The High Court further added 7060 per acre as the difference between tenure rights and leasehold rights that were paid by the President of India and awarded 90,000 per acre. This it did not, notwithstanding the fact this was conscious that there was no definite date for full addition that had been made because of its view in case of this nature certain amount of estimate has to be made which may even be arbitrary. Accordingly, it awarded compensation for 4.65 acres of land which was acquired by the government at rupees 90,000 per acre together with 15% solution table under clause 2 and 23 of the Act, 8% compensation for cedents of land from the claimants. Other portion of land remained with them after acquisition, which was awarded the Judicial Commissioner to Nagpur, which was disallowed on the ground there was an entrance to the back portion of the land which was left with the owners, and because there was no evidence to show that in fact there had been any depreciation in the value of the remaining area, if so, to what extent. On the other hand, it maintained that 10% of the market value of the land awarded by the Land Acquisition Board on account of increase in the potentiality of the land, the basis adopted by the High Court in challenge to the ground they were contrary to the well-established principle applicable for determining the value of lands acquired under the Act. The general principle for determining compensation has been set out in section 23 and 24 of the Act. The compensation payable to the owner of the land in the market value is determined by reference to the price which a seller might reasonably accept obtained from willing purchaser, but in this may not be possible to ascertain with any amount of precision. The authority charged with the duty to award compensation is bound to make an estimate just on objective standard. The land acquired has therefore to be valued not only with reference to the condition at the time of the declaration of the section 4 of the but its potential value also must be taken into account. This is similar to the factor and when my was acquired, the potential value after 71 should be taken into consideration. The sale deed of land situated in the vicinity and the comparable benefits and advantage which they have furnished a rough and ready method of computing the market value. This, however, is not the only matter. The rent which owner has actually receiving at the relevant point of time, or the rent of viewing lands of a similar nature or teaching, can be taken into account by calculating the rent is according to the prevailing rate of interest 20 times the annual rent. But this also not a conclusive method. This code had the special allocating officer Bangalore T. Adanya City indicate at page 412 the methods of valuation to be adopted in ascertaining the market value of the land on the date of notification under section 41, which are opinion of experts. The price paid with a reasonable time in bona fide transaction of purchase of lands acquired or land addition to land acquired and possessing similar advantage, a number of years purchase of actual or immediately prospective profits of the lands acquired. These matters, however, do not preclude the court from taking any other special circumstances into consideration, the requirement being always to arrive as near as possible an estimate of the market value. In arriving at a reasonably correct market value, it may be necessary to take even two or all of those methods into account in such as abject valuation is not always possible, as no two lands may be the same either in the respect of situation, extent of the potential, nor impossible, or case of any reliable material which that valuation can be accurately determined. With my Lord Commission, I take pause here, Lord. It's saying, Lord, even the meaning thereby, even there is a sale deed. The thing you have to take all the consideration in your this is the meaning my reading of this. Bearing this principle in mind, we do not think that High Court was justified in adopting the registered sale deed agreement C1 executed by the Ranchi Club in favor of the President of India, because that land is further away not only from the land acquired but from the town, though it is on the main Ranchi Chawar side. Here it is clear. So, Milord Ranchi Club is on the Ranchi Chawar road, not the land which was acquired under Premi Devi case in Ranchi Chawar.
What is the location of this land?
Ward number 3.
Which location?
Location is not mentioned here, but ward number 3.
Of Ranchi municipality.
It's not there, I can't guess. I am in ward number 4. This is 1954 acquisition. Military purpose, I don't know why they have not adopted the acquisition. So this was not requisitions here. Then Lord, even the High Court recognized, Lord, in this case, Lord, this
What was the case number of the High Court judgment?
Appeal from the judgment and order dated Lord, in the bottom of the first page, in the bottom of the first page, it is written, my Lord, appeal from the judgment and order dated February 25, 1965 of the Patna High Court in FA numbers 437, 438 of 1959. I'll try to find out this.
This is in the first page.
Yes, in the first page. In my Lord, it is 1972, 1 Supreme Court cases 480. 1972, 1 Supreme Court cases 480. In that, Lord, in first
It is
page,
mentioned, what is it mentioned?
it mentioned, Lord, appeals from the judgment and order dated February 25, 1965 of the Patna High Court in FA number 437 and 438 of 1959. Reported in 1972, 1 Supreme Court cases 480. So, my Lord, I was reading here and along with that. Because entire case my rest upon this. I leave it to my Lord, whatever the date my Lord will fix, we will have to have no option to accept. Last 42 years, last 3 generations, at least they get some money. Even the High Court recognized that, I'm in the paragraph 5, Lord, 4th line, 5th line, Lord. Even the High Court recognized that there was no definite date for the 2 additions and that have been made in our view, it would not be proper method to ascertaining the value of the land acquired. The only 2 documents that may be considered are Exhibit 10 and Exhibit 11, which are in respect of land situated in the vicinity and on either side of the land acquired. The other sale deeds are of smaller area and do not furnish a proper basis for ascertaining the market value and have been quietly, properly not relied upon by the learned advocate for the claimants. I am stressing this line not because that is not Exhibit 9, not that 1971 date, a very small plot of land. Had acquired the words the other salaries were smaller yet do not furnish a proper basis to market have been acquired properly not relied upon by the learned advocate for the claimants. The annual rental value of the land acquired.
Normally, smaller area will fetch higher price.
Yes.
So when you talk about Exhibit 9,
but that
it is in your favor only.
That sale deed, Lord, that he, Lord, the assistance of the court, Lord, it is to appear in other cases. That sale deed must satisfy the concerns of the court that is the genuine sale deed.
That you have argued yesterday.
There are other material. That's why it is said in the theory they will not steal the my lord the Justice Khanna is relying maybe after 56 years in one of his judgment. Then Lord Ranchi would show that landowners have given a concerned military authority on behalf of the claimant granted Reliance Plate SU Tekar and sale deed executed dismissed by the claimants of Ranchi automobiles an area of 1 Biga 17 Kata equal to 7 area after deducting 15403 price of structure according to the engineer report 1959 made value of the land 129697. This value would work to rupees 208. The High Court rejected the competition on the ground because the land was contiguous to the land under competition, neither the value of pump other structure belonging to the Burma sale nor the value of the structure that might have been on the land of the date of sale were built in the village and village could be ascertained either from the sale date or the evidence. The agreement is a lease of 13 acres granted by the owner of Thakur Chamka on listing of the disputed. The High Court calculated the monthly rental of the land under calculation the rate of not less than 2,000 per month and 24,000 per year on the basis of 20 times of annual rate compounded to reach 4,80,000 as a market value which works at rupees 103226 per area. It is however pointed out on behalf of the claimant the High Court made a mistake in thinking the rate of the land leased under Exhibit 10 57 and on the basis of calculated the annual rental value of checked the figures from the original lease and find that I paid 175 and not 157. On the basis of the rate per acre of 20 times annual rental value would come to 126,000. When the exhibit 11 is to be taken as the basis of the value of this structure as given by the engineer in exhibit 25 to be accepted. That cannot furnish a proper basis because the land in question is small area, 617 is just over half an acre. The smaller areas such as this on a main road will certainly pay a higher price compared to a larger undeveloped area, even though it may have a frontage on the main road. In order to develop that area, at least the value of 1/3 of land will have to be deducted for the road drainage other amenities. On this value, the value of land at the 2,08,1357 per area would, after deduction 1/3 come to 138,757 per acre. I take pause here, Lord. By reading of this para, it means that ward number 3, the land which was acquired, was also undeveloped. It was not as if it was developed area, that was this much of rate was given. On the basis of the rental of 175 per month, that will gain value to increase as rental was lot for quality in 26,000, allowing for increase of rents for 1950 to 1954. The date of section 64 notification say 5% of the value per acre may be 1,33,000 of the road. If we take the average of exhibit 10 and exhibit 11 as computed by value per acre, it will come to about 1,35,000 in our view. Here is also average not taken. In our view, the value per acre will come to 1,35,878. In our view, 1,35,000 per acre will be a reasonable rate which compensation will be awarded to the claimants. The High Court was not justified in giving 20% towards potential value because the limit inherent in the fixation of the market value of the land and could not be assessed separately. The High Court was also not justified in disallowing 5% awarded by the Judicial Commissioner as compensation for severance merely because there was an entrance to the road land. When a portion of the land is acquired and a large portion left out, there would be a diminution in the value of the land, and that is left out for which the safe convention has not to be allowed. The 5% allowed by the Judicial Commissioner could not be reasonable in his view. The claimant would be entitled to degree as per the respect of land acquired at the rate of 1,35,000 per acre. 5% severance, 15% solution on the market will be computed at interest at 6% on take or taken position. These appeal of the claimants are allowed to be extended to the relation and those of government are dismissed with cost. The claimant will be entitled to proportionate cost of difference between the amount agreed and those are not allowed. So by reading of this judgment, Lord, I summarize this word. Let respect Lord. This land was also not fully developed land, still it's also undeveloped. It was in ward number 3. Sale deed was produced, that was not considered. So my submission to you, Lord, always the sale deed which was produced, only that basis in market value should be determined. This is not the law. You have to see the totality, assumptive potentiality, that those factors I have seen.
And also the development charges.
Development charge.
Which was deducted to the extent of 1/3.
Yes, Lord. That after that 135,000, 1,35,000. In the year 1954, I am in 1971. Ward number 4. Lord, 41,000 given by the arbitrator. It's not great injustice, if I may say, Lord, to say. One number 3, 52, not to 20, not 54 to 71. How much development would have been taken place? Despite that fact, I will be given a lesser price. This one is also there, it is not there, it is situated in the Rathi town or nearby this Abadi. See what is associated under.
Nothing is discussed.
No, one para kindly see, Lord, we can infer from that. Lord, kindly have last page 4 of 85. I may allow me to read again, Lord. It is however, pointed out on behalf of the claimants that High Court made a mistake in thinking that rent of the land reached under Agreement 10 by 157 per annum on the basis of calculated annual rental value of 465 acres of requirement. We have checked the figures from the original lease and find in fact the rent is 175 and not rupees 157. On these cases, rate per acre 20 times annual rental value would come to 1,26,000. Even if Exhibit 11 is to be taken as the basis, the value of the structure as given by the engineer in Exhibit 25 is to be accepted. That cannot furnish a proper basis because the land in question is small area 6 acres and just over 1 to an acre. A smaller area such as this on a main road would certainly fetch a higher price compared to a larger undeveloped area, even though it may have a frontage on the main road. So, one can infer that my lord discarded the small portion of the land, saying because you can't do that. This is the this, my lord, I have shown, my lord, this exhibit, my lord, this is a Supreme Court, my lord. So, my lord, I mean, again, in cost of repetition, I am saying, my lord, 40 may, my lord, may not be, I may not be for entitled for 2 lakhs, which we have claimed. But at least it can't be 41,000 in my humble submission. According to my lord, this, if my lord, this appreciation is my lord, in many judgment of the Supreme Court, 6% to 10% appreciation increase is very many judgments. If we take my lord the appreciation from 1,35,000, it comes to my lord being more than 7-8 lakhs. And 41,000 my lord.
You have claimed only 2 lakhs.
I leave it to my lord, whatever my ultimately the my lord, they all are poor, illiterate, and Lord, one I will also let to judgment. My lord, now my lord, earlier Land Acquisition Act judgments or my lord on different types. In coming days, judgments which were coming, it's the pro claimant. 2-3 judgments, my lord, one bypassed by the. I'm sorry, but actually yesterday I claimed you. Lord, Justice Kurian judgment, Justice Nariman's judgment, Justice Sikri's judgment, where the Lord question was arose, my Lord, whether the claimant claimed a rate, supposedly 100 rupees, can court grant 100 rupees without any pleading?
But that is
court,
settled now.
Court say
that is settled now.
That's why I'm saying that for cost of repetition, that court is saying that court's hands are not tied.
That's
Courts has to ultimately do the justice, see the entire record and pass anything. So, my lord, now, my lord, it's the violation of 300A of the Constitution of India also. Here, which is written, my lord,
इसका जरा 25 to 65 का judgment. Docket number 437 and 438 of 1992. नहीं, ये 1972 के जजमेंट में ये रेफरेंस मिला है, ये जजमेंट जो हमारे यहाँ के खड़ी है, ये रांची बेंच का जजमेंट से गया था ना, रांची बेंच से गया होगा, पटना से नहीं गया होगा, रांची बेंच से। 437 and 438 of 1959. विद ब्रैकेट आर लिखा है कि नहीं, आर नहीं लिखा होगा, ये ट्रांसफर हुआ होगा वहाँ से, जब 73 बना होगा तब यहाँ ट्रांसफर हुआ होगा। अच्छा, डिस्पोजल भी उसका पहले का है, तो बेंच बनने से भी पहले 65 का है, तब रांची में तो उसका कोई ट्रेस नहीं होगा।
So, my lord, I'm just though my lord has said settled, So these on this game, the view of the code has been changed.
कौन सा पैरा रेफर कर रहे हैं?
Yes, paragraph 6-7, this heading
Of 16.4 or 17.9?
just give me one minute. I'm there heading 5, 4, 17, 18.
This is on the point that just compensation.
Just how the
Even if the claim is less.
claim is this. One line I am reading about page 431, paragraph 2. This is 2017 judgment. Page 33, last 4 lines of paragraph 2. The High Court has limited the compensation of the 115 per square yard because they are reasoning that the appellant has demanded compensation at the rate only and had paid the court fees also accordingly. Therefore, find the High Court was difficult to allow the compensation at the rate higher than the rate claimed by the appellant. So it was discarded. So, my lord, the pro-claimant now, my lord, I'm not saying you give pro-claimant means they are entitled to get 10 lakhs, 20 lakhs, whatever they want. But at least, my lord, that something has come, there should not be any injustice on the lord in future perspective. No, the ma'am. My lord, in 2016, my lord, that paragraph 7, 2016 court, Supreme Court cases 544. What is on land acquisition? They said that pre-amended provision puts a cap on the maximum the compensation may court should not be beyond the amount claimed. The amended 1984 compensation puts a cap on the minimum compensation cannot be less than what awarded by the land acquisition office director. The cap of maximum has been expressly omitted. The cap will be only on minimum. It is clear that the amount of compensation that a court can award is no longer restricted to the amount claimed by the applicant. It is duty of the court to award just and fair compensation taking into consideration the true market value of the relevant person. Court's power to, Milord, generally court powers is also to lower down, but generally, Milord, when claimants comes to the court for expecting something, generally courts increase in 90%. Now the court powers is also there, you have not. 99% Milord, the courts is. Can you see, Milord, one exhibit, the future perspective, Milord. We have exhibit 13. Last page, Lord, I'm just saying. I'm just for saving court's time, Lord. Last page. रांची नगर पालिका क्षेत्र से 1 किलोमीटर की दूरी वाले ग्रामों की सूची.
Last page of?
Last page of 13. Completed argument, sir. This would have.
This is exhibit 10. Exhibit mark 10. Exhibit 12. Adhisoochna. ये notification. ये जो notification है. इसका last page. इस notification का last page है. This is for appointment of arbitrator.
I'll check below. Then, Lord, in my counter affidavit, written submission, my Lord, filed before the Honorable Arbitrator. Here, my Lord.
Written submission must be there in the records received
Yes,
from the learned arbitrator.
Yes, written argument filed before the learned arbitrator.
No, we will. You just tell us why do we need to refer to that?
Yes, for one reason.
Because written argument by itself does not form a part of the record.
I'm-
Record is the evidences placed on.
Yes, but I am saying, Lord, the written argument, if you have stated something,
No, written argument is just for the assistance of the court. It does not form a part of the record.
for assistance of the court, Lord, for assistance of the arbitrator.
So whatever it is, if arbitrator has omitted to see anything, you just tell us that this has been omitted. Why do you need to refer to the written argument?
No, for the assistance of the court, only one line I am to just allow me.
Written argument does not form a part of the record. I cannot pass any judgment based on written arguments which was filed before the learned arbitrator.
This is the part of the.
It does not form a part of the record.
Part of the record, Lord.
It does not form a part of the record. Written argument is only for the assistance of the court. What forms part of the record is the claim, the evidences placed on record, that forms a part of it,
But
not the written argument.
But I'm just allow me to read only.
Suppose
one.
I ask you to give written arguments, which I will, right?
Yes, Lord, I.
That will not form a part of the
Yes,
record.
yes.
That is only for the assistance of the court.
Assistant, but from the written argument, if something has been missed, Lord, by the court, generally we say that.
No, if any evidence has been missed, you can just argue that it has been missed. But why do you need to refer to the
No,
written
in
argument?
my written argument, we have expressed our belief that we are confining to these 4 exhibits.
Here also you want to confine it to these 4 exhibits.
Yes.
Which 4 exhibits are you confining?
2 I have stated already in Lord.
Exhibit 412.
412 here I am
412.
praising very much.
And
But before the arbitrator, 2 more were.
which were 2 more? Exhibit number?
Yes.
Once the materials comes before the court will see everything.
Yes.
Yes, because the court has to come to a stage of just compensation,
Yes.
irrespective of your claim.
Yes. Yes.
So,
Yes. I leave it. No, my Lord. So far as Lord, our 4 were examined on our behalf. Yes. 3 were examined from their behalf. If you may allow me 2 minutes, because both the party has to put their claim before the arbitrator. I may feel they have to produce something.
kindly see
When
there,
you are the claimant,
I am the claimant.
it's your responsibility to say that the compensation which has been offered to me is not fair.
That I
And for
am
that purposes, you have to lead evidence, and you have led evidence.
I am saying कि in their deposition also, whatever stated in my deposition, they have not discarded.
Need not. You see, deposition is not discarded by another deposition. Deposition is discarded by cross-examination.
Even in cross-examination,
That's it. You can see. You have read it.
I have shown, my lord.
You have read it.
The third limb of argument, my lord.
What do you have to say on solatium and interest? You have placed the exhibits, you have placed on the quantum, you have
Yes.
placed on the location of the property. You have placed the judgment by which the
Yes.
arbitrator was appointed. Now the
Now,
third,
my lord, third limb,
the last limb perhaps,
Yeah, last.
solatium and interest.
solution. My lord, as on today, the law is that Land Acquisition Act and the Acquisition of Movable Property Act are different. In Hari Singh Khosla's case, other case, I don't know when it will go to larger bench, what will happen as on today. But there is a rider, series of judgment.
The judgment has simply said that 28A is not happening.
Yes.
Right? It means that if anybody else has got some enhanced compensation, then there is no duty cast upon the collector to offer the enhanced compensation to others. Right? That principle, that law, that particular section is not happening.
Yes.
But so far as the principles of computation, the principles of quantum, etc. is concerned, it's one and the same.
Yes.
There is no difference between the two.
Yes.
Simple.
Yes. So, my lord, with the rider, there are series of judgment. One we have annexed, that is annexure, my lord.
First, tell us, under this act, is there any provision for solatium?
No.
No. Is there any provision for award of interest?
Interest, there is no provision, but they have themselves 6% interest they have given.
6% interest from the date of acquisition or from
When
the date
the
of the
award
award?
was made, they have
It is from the date of acquisition or the date of award? You have also granted 6% as per your initial calculation.
Exhibit 10, it is written, my lord, 6%.
Let us have a look at that.
Yes.
प्रतिशत होने की तिथि से from the date of notification.
Yes.
From the date of
Obviously,
notification.
date of public is obviously. And here, my lord, since my lord is seeing the exhibit 10, I forgot to make one submission. In this entire year, my lord, I and J form is mentioned. K L form is not mentioned because they did not go to that extent. I have shown you the
That's it.
constitutional bench judgment because it has to be. Once there is no agreement, it has to be. So, my lord, with the rider, my lord, there are series of judgment. Even the Hari Singh Khosla, after negating my lord, the argument, the court said since there is a delay in appointment of the arbitrator, claimant is entitled for the solution and interest. And that rider in the Hari Singh Khosla subsequently followed in many judgments. Some of that, not one we have exhibited, that is exhibit first I will tell the
Solatium will be 30% from which date?
From the award.
From the date of award. From where do you get this? Solatium is on the.
in supplementary award the calculation has been given. The arbitrator calculation is there, you know, at page.
Number 6 of the
Solatium at the rate of 20%.
Of
the awarded amount.
Arbitrator has been given 20%.
20% of the differential of the awarded amount.
But Supreme Court, some judgments is there.
20% of the differential of the awarded amount has been paid, and further that awarded amount and solatium added together, and simple interest on at the rate of 9% has been given. 9% from the
And
date
post award interest 15%.
15% will be computed on what basis?
The arbitrator has having right to allow give the interest, post award interest.
But one judgment they have cited that post award interest.
No, in that judgment, what happened in this case? 12% was awarded by the arbitrator. Here they came, High Court reduced to it 9%. They challenged to the Supreme Court. SLP dismissed. When the SLP dismissed, they filed a contempt petition. In contempt petition, court said no. We reduce 9%, you give that 12%. Against that, they went to the Supreme
You see,
Court.
I just can't tell you. You place the judgment because they have placed it yesterday. That there cannot be further compounding of interest.
It's not compounding of interest. Because I thought the same, because the study I was handicapped. Now as per the 37 Arbitration Act, 34 of the CPC.
You see, Arbitration and Conciliation Act, 1940 Act is not applicable.
apply, but I am saying the principle, like you say 28 is not applicable, the principle for giving post-award interest is now been recent judgment in Supreme Court. This was reference was made by 3 men, and that it is the mandatory. That principle I will produce. So, my lord, this is the solution and interest. One exhibit we have not put. That was exhibit, my lord. Lord, if not so, my lord will pass a judgment, and they will keep quiet for 30 years. 2014, the award was passed. They have not taken any stay. They have not put any in the bank. So claimant will suffer, my lord. God is silent.
No, they say that the future interest would be computed on the principal amount. This is what they say. But they do not say that the interest would not be payable. They say that the interest would be payable.
That original order where the High Court had granted 9% interest, that was of 2007. That was dismissed by the Supreme Court. That was not dismissed, my lord.
You are not referring to the judgment. Which judgment did you cite?
Which they have cited.
Which judgment did you cite yesterday on this?
For that, my learned friend, no, not me, sir.
They cited 2010 3 SCC. Senate. Yes. You place this judgment and distinguish what you want to say to this judgment.
That's why I am saying I have read the judgment.
Please read it once.
My learned son, senior, is in a better position because in yesterday he had made some research on that. Yesterday, as I told her, I was not in a position to make it. I was trying to find out, my lord, the High Court order of this, in this Senate Munda's case. Because if you see, my lord, the original order 2007, that was upheld by the Supreme Court. So that order I was trying to, my lord, give some indulgence for today, my lord. I will have some medicine, then something I will do.
No, we have to conclude it. You see, we just can't go on like
No,
this.
till tomorrow I am here, my lord Ranchi.
It's
Till
true that
tomorrow I am
way.
here in Ranchi. Till tomorrow I will conclude.
So primarily everything is
No,
otherwise.
so only solicium and.
Solicium, you have said that if there is a delay in appointment, there are judgments
There
which says
there
that.
is two exhibits. One exhibits, my lord. ये exhibit 5.
Yes.
This is the, my lord, of this honorable court. Here the solicium and interest was granted, and it's reached its finality, subject to correction if they have challenged this order to division bench or Supreme Court.
So Nijarwa Lakda went up to Supreme Court also.
I have to check.
Yesterday we have seen that one. It went to Supreme Court also. Anyways, but solicium and interest was sustained.
Sustained, yes. This is, my lord, that question was put to me, my lord, that the arbitrator was average. I will definitely today sit 2-3 hours to find out. Actually, I gave that SCC key in Delhi.
You have your password, you can access it here. You don't have your SCC online password.
There are two things now. One is online,
Offline.
one is key.
Offline.
Key is provided, you put the key, that brain drive, then it will come. Yesterday I asked my near when the library is open here.
Library is open. You can
Here is saying he told me maybe around 10 o'clock in the morning. I said in the Supreme Court 8 o'clock morning open because 1.5 an hour we used to. This is, my lord, the so far as solicium and interest judgments I am handing over, my lord. That one, my lord.
That's all.
Yeah, because two, 3 things more. If my lord in hurry, so can I will place only 10 minutes I will take tomorrow. So for a maintainability of their appeal.
Their appeal is not making.
Because, my lord, they are beneficiary.
Who are beneficiary?
The defense state.
Both of you are beneficiary. One is getting the money, other is getting the land.
But
law says, my lord, I leave it to my lord, I'm just placing because I am being briefed to say that law says when you are filing an appeal, you have to take a leave.
This appeal has been admitted after hearing on.
And secondly, my lord,
Please don't. Please
I
don't.
will. Secondly, my lord, because
ऐसा ऐसा बहस मत करिए कि हमको लगे कि बस अब आपके पास कुछ नहीं बचा बहस करने के लिए।
क्योंकि हम ब्रीफ होते हैं तो मैं बता रहा हूँ
नहीं, थोड़ा सा अपने ब्रीफिंग काउंसिल को भी थोड़ा सा कंट्रोल में रखिए कि कुछ ऐसा बहस करिए कि जो सुनने में भी ठीक लगे।
Yes, my lord. In one case, my lord, that is Hari Mahato, and that there, my lord, the whole hearing area there was no soliciting interest. Matter went to the Supreme Court. I argued there, so I was since arguing. The my lord did in hearing. He reverted this CCL. How can you represent union of union?
They are union opinion.
A defense state.
No, they are union opinion.
But represented by defense.
Whosoever.
And I leave it to that. So soliciting interest not passing on this judgment, my lord. Yes. One was executed also. One was executed also.
नहीं, ये जो आप जजमेंट दे रहे हैं ना, पैराग्राफ बताइए, ऐसे नहीं आप इस तरह से आप जजमेंट
I'm sorry, Lord, yesterday I was handicapped. Tomorrow, my Lord, 5-10 minutes.
नहीं, इसमें से बताइए ना पैराग्राफ, ये जो अभी आप
I
साइड
have
कर
to
रहे हैं।
read.
You have not read it and you are citing.
No, I have read, but paragraph, exact paragraph number. Give me 10-15 minutes tomorrow, Lord, I am there till 4 o'clock in Ranchi. I will not take more than that. I may not be incorrect, Lord, that's why I say.
And so many judgments which have been annexed along with your written submissions.
Yeah, that I
None
have
of them have been cited
no,
except one.
I personally see will put para number, everything. Because yesterday I was handicapped, Lord.
कल आप written submissions के साथ लेके आए।
Yes.
कल written submissions के साथ लेके आए।
Yes.
इसका पैरा नंबर जो भी है आप
Yes,
सब लेके
yes,
आए।
Lord.
Because after I get the written submissions also I would like to hear. क्योंकि written submissions में कोई भी चीज़ वो नहीं होना चाहिए जो आपने बहस नहीं की।
Yes,
या कोई भी ऐसा चीज़ नहीं रहना चाहिए जो आपने साइट नहीं की।
तो
नया कहानी हम written submissions में रहता है, पूरा written submission हम reject
no,
करते
that is not permissible.
हैं। This is happening in High Court.
In our
In our High Court this is happening. That is why I am
there
careful
it is
about it.
was not permissible.
आपको क्या बोलना है in response? Do you have to say anything more?
No.
That's all?
Largely everything has been
Okay.
covered by my lord.
Okay. Yes.
The
Do you have to
judgment
say?
which is reflected by my lord.
Yes, already completed. Yes, already completed. What else do you have to say? What do you have to say in response? Where is your written submissions?
They are saying this.
No. It can't be like this. After the written submissions also I hear one day. So you file your written submissions tomorrow. You have not made many very elaborate arguments. So written submissions में elaboration का ज़्यादा scope भी है भी नहीं. File करिएगा तो हम reject कर देंगे. I'll cite reasons to reject it.
We not make any submission.
So therefore, you file it tomorrow, and I'll hear both of you on the written submissions, whatever submissions are there, and then I will dictate the judgment.
Rejoinder with the points which have been made in rejoinder, with that at least we can improve in our written.
They have not argued any new point.
From record of
For example, there was one was
What is it that you want to rejoin? In particular, tell us.
one aspect to be rejoined will be the observations which were made by the Honorable High Court in the writ petition which was filed by them, the 20 writ petitions which were filed by them. There were certain observations which were made with respect to the whether at all there was any protest which was filed by them, number one.
That you have already argued.
that
Please
has
don't
been-
repeat it.
That has been overruled, my lord.
No,
See,
no, just a moment. You see, you have already argued that point. You have already argued, and you see, the point is that you say that there was no protest. There was a what do you say, deemed agreement, right? That I have taken it. You see, the court, the arbitrator has entertained that point and decided it. Correct?
Yes.
And your case is that there is a deemed agreement, and therefore the adjudication was to be confined only to those persons who had not received the compensation.
Not only the aspect of deemed agreement, we have also placed one judgment clause wherein it has been stated that the onus to raise objection clause.
That has
Yes,
that you have already placed.
That aspect.
That you have already placed.
Because they have cited certain judgments clause today, which because I have taken note of clause just in order to rebut them because
They have primarily placed the evidences on record.
yes, just in order to rebut because they have even most of the exhibits clause which have been relied upon by them because they are also judgments. Mostly. But what will be the implication of a prior award? Because that aspect was only limited to that aspect was correction.
Okay, but your written submission should come tomorrow. Your written submission has to come tomorrow. Or I will not permit you to file. You have only two options.
Not at a general trade, not even in Supreme Court. The Union of India will file written submission in the night, 2 o'clock, 3 o'clock, after receiving.
No, you have to file it simultaneously. There is no question of first exchanging. You will exchange it during the court proceedings and you will file it simultaneously.
That practice was
This is how it is.
yes.
At least, so far as you are concerned, in your main agreement, you had referred to give me the list of the judgments that you have read.
Yes.
Where is it? You have it?
I have all the hard copies were given, but I'll make a list and I'll give the compendium itself, along with all the relevant paragraphs and the issues. If permitted, that can also be done tomorrow or today itself.
No, you do it tomorrow. There is no problem. You just put everything there. And tomorrow I will also dictate the judgment. I will hear you, I think, half an hour should be sufficient from
Yes.
both the sides.
Just in my duty, because this one point was being deliberated upon yesterday in the chambers. Article 137 Limitation Act vis-a-vis the RAIP. This deliberation was going on, so that is my duty.
137, where the deliberation was going on?
Because in my senior plus was deliberating on this issue, whether there will be an implication of Article 137 vis-a-vis the claims under the RAIP. It is my duty to just point out that discussion below at least the
So all those cases where the arbitrator has been appointed after 40 years, after 30 years, they were all barred by Article 137.
I was just pointing out that this deliberation was
They have completed. You rejoined.
I had requested for Friday. Tomorrow I will reach you.
Tomorrow with your written submissions.
Yes.
I will hear you on the written submissions, both of you.
I will give you in advance before I.
Yes, of course. At 10:30 you exchange yourself and give it to us.
Yes.
Give it to me.
Yes.
And whatever you have to say, you refer to the written submissions wherever you have stated.
Very well.
And I will hear you also on the written submissions, whatever you have pointed
Yes.
out.
Yes.
And then I will dictate the judgment.
Yes.
And the list of judgments
That
which
you
you have
are reading the
cited,
copies.
which you have cited, you have to put it in an index form
Yes.
with relevant paragraphs. And judgments which you have not cited, please don't cite. If you want to cite any judgment in rejoinder,
Yes,
you
yes.
can, but
I
primarily,
do understand.
you see, they have given so many judgments and placed none of them.
I can understand.
I will not take it like this.
Unless I place my reliance, how can I?
This is
Unless
not
I
permissible.
put the things in motion, I cannot.
Judgments which you do not cite, I will not consider. Okay. Tomorrow. The arguments have remained inconclusive. Post tomorrow at 10:30. And rest is all understood. Right?
And one small request subject to your issues that item number of the supplementary. Because I found because he was having the soft copy, I found that none of the exhibit with leadership had all the entire record and returned back after scanning. From the scanned document, we could find that there is nothing, none of the exhibit is reflected. Hard copy is still there.
Hard copy of?
The record, but none of the exhibits are there. how to refer the things?
कहाँ से आया record?
यही Deputy Commissioner Ranchi, Office of Deputy Commissioner. We have verified the entire record. Associate Council was verifying from morning.
दिखाइए सर record.
Soft copy here.
दिखाइए जरा record दिखाइए मुझे केस है अलग से.
Supplementary item.
इसका ना सिर्फ एक पेज है चाहिए. Page number 4 is missing of the final judgment.
And what we propose to rejoin can be incorporated in the written notes.
Yes, you can incorporate.
1200 pages. Scan was given utility page 1025.
ये वाला पेज मुझे बोला ये रिकॉर्ड से मिसिंग है तो ये वाला पेज उसमें निकाल के ना उस एग्जिबिट पे लगा दो.
And if possible, that matter can come next week.
No, I'll just see. You are saying
Yes.
that there is no
Exhibits are
record.
not there. The record is there 125. Repetitive pages are there. What is there, but no statement of claim is there, no reply is there.
Statement of claim and reply is apparent from the award itself. Why do you need all
What is
that?
the stand leadership in first?
No, so you deposit the amount and then you argue whenever you want.
No, next week itself I will be arguing. I am not sitting for a longer day. I have called my
And then
statement.
again you will say that the records are not there.
Did I say in this matter? I took time, I argued. For this 400 cases, I cannot be faulted.
All the records are there.
Now the exhibit is with
Sorry? Exhibits are there. All the exhibits are there. Next one.
Next, इसमें नहीं बोल रहा है, इसके लिए next में. This you have argued, whatever is there based on that you have argued. The next matter that is the supplementary.
लाइए सर
Item
दूसरा
1
वाला.
from supplementary list.
इसका रिकॉर्ड.
इसके लिए तो टाइम नहीं, कल रिलाइन करके कंप्लीट करेंगे.
ये जो सनीचरवा लकड़ा वाला जो केस था वो सुप्रीम कोर्ट गया था उसका आप साइटेशन नोट करें.
Yes.
सिविल अपील नंबर 8283 of 2002 and 8287 of 2003. It was decided on 21/2011.
Alright. That is in the second record which we will issue.
हाँ ये वाला जो ऑर्डर है ना इसका एक कॉपी हमको इसके लिए चाहिए. इसको निकाल के कॉपी लगा देंगे. अच्छा ये कहाँ से आया है रिकॉर्ड?
Deputy Commissioner Ranchi. ये दूसरा record.
Who was the arbitrator?
Vikramaditya, Justice Vikramaditya.
May I take leave?
हाँ.
Compliance.
Para 7 from the award, the judicial will find that these all exhibits are reflected.
Para number 7 of the award.
The award is after the framing of issue. Exhibit 1, Exhibit 3, Exhibit 4. The next Exhibit 2, he has come 4 by 1, 1 by 1.
It is primarily connected with notices, so
That is one of the issue that was before that no notices has been served.
no, this is in connection with identity of the persons.
What couple of documents, then the notices that was served to them.
It is immaterial, please do not go by this. नहीं तो आपका एक केस कर दीजिए.
नहीं हम नेक्स्ट वीक में आई वाज रिक्वेस्टिंग
I will give you next week.
Next
ये
week
कोई
है.
रीजन नहीं है कि
नहीं रीजन हम प्लेस कर दिए
जरूर.
यदि उसके एब्सेंस में भी हम बहस कर सकते हैं तो हम डेफिनेटली कर लेंगे.
आपका दो ही चॉइस है आपके पास.
हाँ
ठीक है.
पैसा जमा कर दें या टाइम
पैसा जमा करके हम लोग
हम नेक्स्ट वीक
कॉल फॉर करते हैं.
नहीं नेक्स्ट वीक हम
हम 2-3 साल बाद करते हैं.
नहीं नेक्स्ट डिड आई फॉल्टेड आई एम पुटिंग डिड आई फॉल्टेड यू
देखिए,
कॉल्ड मी
जो चीज मेन मुद्दा है ना,
उसी को अच्छा बताइए हम कोई मुद्दा से भटक के बहस
नहीं,
किए.
मुद्दा से नहीं.
झारखंड हाई कोर्ट के लॉयर मुद्दे पे रहते हैं. डोंट डिस्प्लेस हियर एंड देयर. And my learned senior friend, he was relying on some judgment. हमको ये पूरा तैयार नहीं कर दे दीजिए कॉपी ऑफ जजमेंट.
दे दिए
हम लोग को कहाँ
आपको लिखा दिया.
सीनियर इस तरह से काम है. कॉपी नहीं.
I am relying on two judgment mainly. There is 1995 volume 4 SCC supplement SCC.
नहीं एमए वगैरह जो बोले थे सिल्वर केसेस में.
सिमिलर केस का तो दे रहे हैं अभी है. It is ready with me.
तो दीजिए ना. सोच क्यों नहीं.
उनका कंफ्यूज हो
दीजिए कौन सा ऑर्डर आपको लेगा.
Thank you.
And that we have given that all over the high court. We traveled in the earlier note. I was ready to say. I wish once you would share the both.
Yes.
Because certain confusion will be at least dispelled.
See entire record, the entire judgment, right from filing the writ petition till the Supreme Court. In three
एक
matters.
कॉपी चाहिए हमको. I need only one copy.
In three cases.
अच्छा.
Three cases, same notification, same village.
अच्छा. सेम नोटिफिकेशन का.
हाँ ये जो ट्रैवल किया सुप्रीम कोर्ट इन द सेकंड मैटर.
Ultimately, the matter has been settled with solution and interest.
I will be arguing.
Because he is referring to three different
I will be
notifications.
arguing.
With respect to the same village, and he says that the matter travelled with up to Supreme Court in connection with कौन सा वाला गया है?
तीनों.
So the
तीनों गया है.
Yes.
और ये वाला जो है ये भी same notification
Yes, yes.
and same village
Same notification 13/1/87.
and same village.
Same village.
Same village.
I will.
Practically,
थोड़ा सा देख.
practically, my lord, more than 17 cases of the same acquisition. Date of notification may be different. Collaterally came, went up to the Supreme Court and all have been correct. एक केस में सेनेट पुंडा में एक करेक्शन आया कि इंटरेस्ट जो अवॉइड में आया है, इंटरेस्ट पे इंटरेस्ट नहीं. वो एक
The judgment which I cited,
I will next
it is part of that judgment.
आप कौन सा इसमें लगाएं?
हाँ, सेनेट पुंडा में लगा हुआ. That is last page. 2010 का जजमेंट है. It says that interest पर interest नहीं है. That is civil appeal number 2290/2010.
The last वाला judgment इसमें है.
This is para 12. We are of the considered view that payment of interest at the rate of 12% per annum from 22/2003 से 25/11/2006 on the amount of ₹1,00,000
lakh, 1 crore 37 lakh.
Yeah.
That amount.
Interest पे interest.
Interest on interest.
That's one judgment.
That you are cited.
This is the one. This is one.
This is the
Now the
correction.
component would be the awarded amount,
Solatium and interest.
solatium, just a moment, awarded amount, solatium. तो ये दोनों बन गए principal amount. हाँ, मतलब as I think so.
Yes, if it becomes a principal.
Both these things they become principal amount.
Solation, because Act does not prescribe, and in belated stage inordinate such.
In order to compensate, solatium already दिया जा रहा है. In order to compensate delay.
delay, so it will not become principal amount on the first day.
Yes.
Delay, it will become on the awarded date.
Yes.
It will convert itself into the principal amount on the awarded date. Because
On the awarded date, तो उसमें solation पे back interest नहीं लगेगा.
नहीं लगेगा.
जो 9% या
Yes.
12% जो भी दिया गया.
Because that is itself in the shape of compensation.
And so far as the final award is concerned, उस पर दोनों जने मिलकर प्रिंसिपल बनेंगे और उस पे इंटरेस्ट चलेगा. इंटरेस्ट पे इंटरेस्ट नहीं चलेगा.
तो फिर वो 9% जो आया पीछे से.
हाँ, उस पे नहीं चलेगा.
उस पे नहीं चलेगा.
But you see, it is like this. There are three components.
Yes.
One is the award, principal amount. B is the solation.
Solation.
C is the component of interest on the award. ठीक है, ये तीन हो गया. उसके बाद जब अवार्ड बनेगा फाइनल, A with B and
If I say A plus C plus B,
A plus
plus C, interest will go with that award, and B will add on to at the end of the day when the award is pronounced.
when the award is pronounced,
A plus C will run, B will add on the date of it.
and the future interest will be paid on A plus B plus C.
No, C has to go. Then again it will be interest on interest. So that executing court will take care of.
प्रिंसिपल सम एडजस्ट पे नहीं चलेगा. सुप्रीम कोर्ट बोल दिया था हम कुछ करेंगे नहीं. लेकिन प्रिंसिपल सम एडजस्ट
That is the
that
arbitration.
includes the.
That is the arbitration.
That's right. That is the general principle of law.
But
That is not arbitration. That is a general principle of law. That is referable to CPC.
go down.
That is a general principle of law.
But
लिखेंगे लेकिन करेंगे वही जो आपका जजमेंट आप दे दीजिए और
अब justice last judgment is there, right or wrong.
क्या?
Justice Vikram last latest judgment on the point. Whatever we have laid down, it is not to be distributed. It has to be followed.
Well, one judgment is there, in para 61 of that judgment says that once the arbitrator gave his award, it is not to be interfered.
So next
नहीं ये this is not an award. This is not an award governed by 1940 Act, nor it is an award governed by 1996 Act. It is mentioned in the Act
Act
itself.
itself. And neither it is an objection under 34. It is a regular appeal under 11.
It is वो उसमें Act में ही लिखा हुआ है that section this 1940 Act is not. Nothing in the Arbitration Act 1940 shall apply to the arbitrations under this section.
I will show in this act.
Yes, it's in this Act. It is mentioned.
Arbitration 1940 will not apply. That's true. But I will recently I have gone through that judgment.
Which judgment?
Exactly, I don't remember, but I will bring that. Para 61, therefore I am quoting that. Para 61.
नहीं आप कल जजमेंट लेके आइए. आप कल जजमेंट लेके आइए क्योंकि हमको तो पढ़ना पड़ेगा ना उस दिन आप नया नया कहानी.
Well, we will probably
Next, आज के लिए इसको थोड़ा सा
आज के लिए कल
नहीं कल तो ये फर्स्ट मैटर जो 13th है ये वाला मैटर नेक्स्ट
ये वाला भी रहेगा ये जजमेंट देंगे.
दे जजमेंट लेकिन हमको
Let him give his judgment.
but allow me
We will give you time.
because I don't want to fail in my time. Because my law you
आपका हम टाइम आपको देंगे.
जैसे आप 18 बोली तो I have stood by my commitment before this one.
Then we will do it. We'll take
Maybe
it.
we will finish it off. All RAIP और कुछ अपील मेरे पास होंगे I will just place the because front court master so that things should come to a logical conclusion. These are long drawn.
जो है रिकॉर्ड इसी
जो
से
अपना
भेज
ऑफिस
सकते हैं।
रिपोर्ट भेज दिए एप्लीकेशन का रिकॉर्ड नहीं भेज रहे हैं, डिप्टी कमिश्नर के यहाँ जो एप्लीकेशन प्रोसीडिंग होता है ना, हाँ वही है, ऑफिस फाइल भेज रहे हैं। State is appearing in this matter.
Yes, state is.
स्टेट कहाँ है
You can get
इसमें
it.
आर्बिट्रेटर का रिकॉर्ड चाहिए हमें। आप आर्बिट्रेटर का पूरा रिकॉर्ड नहीं भेजेंगे। The depositions and the evidences are not on record.
Not on record, that will be verified. हाँ पूरा रिकॉर्ड
इसमें लिखिए तो
करना
FA number 43 of 2018, the Learned Counsel for the Appellant has submitted that the record of the arbitrator has not been forwarded to this court, inasmuch as the deposition and the evidences placed before the learned arbitrator is not on record.
And the claim and
Has not been
response.
forwarded.
Claim and response, those are also not.
The claim and response is also not available, which might have been filed before the learned arbitrator. Counsel for the state submits that he shall do the needful and ensure that the full records of the learned arbitrator is produced before this court. अवार्ड का कॉपी है
अवार्ड का कॉपी तो प्लेस किए पैरा से
सूचना इसको नेक्स्ट वीक रखते हैं, नेक्स्ट थर्सडे
In the meantime, he can just share.
आप ओरिजिनल रिकॉर्ड लेके आए।
Senior counsel can share the judgment. What is the ruling?
हाँ
Yes, yes, yes.
Give you a list. जितना patient hearing देते हैं कि we also learn many things in process of arguing also.
My lord, may I answer? Next week, there is a marriage in our family. Therefore-
आने दीजिए सर, रिकॉर्ड आने दीजिए,
हाँ.
somebody would be there, I will accommodate, right?
And we can
But
start-
let the records come. ना, if it is not available, तो
No, I
जैसे
will
Vikramaditya
get ready.
Prasad is no more, हम लोग नहीं मंगा पाएंगे।
We will start it.
हाँ.
Basic principle of law.
Whatever, whatever
Basic principle of
records,
law पे होगा, केवल fact उतना ही तक है कि who is at fault.
हाँ
जैसे इसमें paid without protest.
हाँ,
Who is at fault, that has to, because solution is dependent on that.
that's
Right.
next.
Lordship and seek indulgence to mention cases fixed in final disposal
In?
serial or final disposal serial 1 to 7. One additional counter affidavit has to be filed. Earlier also Lordship has provided me an adjournment, and this time only a week adjournment
Week
time.
कौन सा मैटर?
1 to 7 Lordship. Advertisement penalty.
तो क्यों नहीं आ पाई थी?
That is under process within 1 week I will file it.
देखिए, the learned counsel for the respondent prays for one week time to file supplementary counter affidavit.
Additional counter.
Additional counter affidavit. Prays for his and is allowed कर दीजिएगा। Next Thursday को रखेंगे
All right.
या next to next Thursday को रखेंगे? Next to next Thursday. ठीक है?